Good morning. Uh, a vital issue which could be understood was that every human being wanted to have another generation to resemble the father or husband or wife or their ancestral pets, grandfather, great grandfather may want a generation next. See, therefore, delivery of child is most important. What about law when the child is in womb? Indian Succession Act deals with that. What will be the right of the child in the womb? Only after the birth, the child in the womb will have right over the property. In Hindu law, Muslim law, everywhere, there may be bequeath. Bequeath means gifting the property by a will. The will may say that the property will devolve on the grandson is going to born, or those things all are there, but that will have an effect for after delivery of child only. And there is a limitation how long this will be postponed. Postponement of ownership. Suppose the propounder, the person who bequeathed the property died after executing the will, and the will says the grandchildren will have right over that property. So when the grandchildren will be gone is also a very vital question to be understood. These all are for general knowledge. But one vital important is the child in the womb born and dies, and dies in the womb and removed from the female is vital aspect in while deciding the succession. If suppose that was general classes access, you must also have a knowledge on how general classes act plays vital role while interpreting law and constructing the documents, etc. If suppose a woman carrying the child met an accident and dies simultaneously, simultaneously with both the death occurred both mother and child. The law says the senior should the senior person by age should be considered as died first. So here, if suppose mother and the child died, the mother dies first. So what will be the devolvement of the property? The mother's share will come to child one part and one part to her husband. And the child also dies, that share will also go to husband. If suppose the child dies first, thereafter mother dies, then the mother share will only devolve on husband, not the child, because child have no right because it died prior to her mother without inheriting the property. That's it. This much of problems are there, but that apart you leave that all. But very concerning, sickening, troubling, giving depression. Even though we are not directly involved nor our relatives directly involved. Whenever we read newspapers about this gang rape, child rape, it gives some emotional tension. What Nathuram Godse said while giving his explanation for the accusation of murdering Mahatma Gandhi. What the facts and other circumstances caused the sustainment of provocation to assassinate Mahatma Gandhi. Like that, here this by seeing this lot of periodical cases of gang rape, children are becoming pregnant, all these things, somewhat giving trouble. So I want to I had a judgment about that. Probably criminal side lawyers, it is most important because these cases only being approached by criminal lawyers for a termination of pregnancy if the child is very tender age. And apart from that, the Act says, Act deals with pregnant medical termination of pregnancy Act. That deals with which all are the without permission the termination may be termination of pregnancy may be affected, and after certain periods the termination of pregnancy must be obtained through the medical board opinion, all these things, and thereafter court and other things are there. Here one case I would like to discuss is a case of gang rape. AR 2022, Uttarakhand 33, minor through her father versus state of Uttarakhand. They say pregnancy of minor rape victim. Termination of pregnancy found to be 28 weeks and 5 days. Medical opinion that at that stage, baby can be born with many anomalies. Father of minor victim expressed that she is not in a position to continue pregnancy if not permitted. Possible grave injury would be caused to her by physical and mental health. If victim compelled to continue with her pregnancy, it would infringe her life to live with human dignity. Article 21. Living is not sufficient. She should live with dignity. That is guaranteed under Part 3 of the Constitution of India. Therefore, right to terminate pregnancy was granted. This judgment discusses about Section 3 of the termination of pregnancy, Section 2, what all are the period, and when you sought for permission from the medical board should consist of gynecologist, pediatrician, and radiologist and sonologist. And such member as may be notified the official gazette. All these things are there. They have discussed about lot, and finally, referring by Supreme Court judgment, Suchitra Srivastava and Chandigarh administration, and AR 2010 SC 235, they have allowed, they say right to life means that what it is most important. Something more than survival or animal existence. This is what again they have said. This is what they have compelled. So apart from that, I would like to discuss with you what all are the pregnancy problems. I am just imposing, trusting to your mind in mind. You should not avoid this because for God's grace I wish you that you may not come across the problems of these symptoms, complicated patients. But however, being an advocate, you may be approached, your relatives may approach, so you must know what all are the pregnancy problem. Warfarin embryopathy. Warfarin embryopathy. That you should understand. Then Edwards syndrome, trisomy, A chromosomal disorder, non-ossified nasal bone, and bilateral pyelactasis, microcephaly. All these things are some of the medical complication when the embryo in the womb is not properly developed. So I think, though I think I have taken you for a ride to understand the field which you may not like, but you must understand it as a human being, and you may be at now age of 20 or 30 or 35 to 40, but you may be reaching the age of 70, 80, where this knowledge would help your branch trees, genealogical branch trees, members of your family. I hope you understand my endeavor to bring this judgment. Best wishes.